Today we have a CP session on succession planning, wills and private trusts. And for this, to deliver address on this, we have CA Sheshadri with us. May I request our Chairman Pramod Reddy to escort the speaker. Also greet him with a floor. Welcome to you. Now I request Chairman to address.
Good evening, members, and welcome to this pivotal session on succession planning, a topic that resonates deeply to our professional and personal lives. As the Chairman of Bangalore branch, it's both honor and a privilege to host our first study circle program dedicated to unraveling complexities of the succession within the framework of the Indian law. To handle this session, we have CA Sheshadri sir. In our journey today, we'll dwell into the intricacies of succession planning, a crucial aspect that seamless transition of assets, responsibilities, and legacies from one generation to the next. Our exploration will be guided by the cornerstone legislations that shape the succession in India, that is the Indian Succession Act of 1925, the Hindu Succession Act of 1956. And also, we are all aware that the recent draft law of the Uniform Civil Code, which was proposed in Uttarakhand, rather it is passed, the Indian Succession Act of 1925, a comprehensive statute that lays down the legal framework for the succession of the property of individuals who does not fall under the ambit of special religious succession laws. It is the testament to our country's legal foundation, ensuring that the succession is governed by the principle of equity, fairness, and universal applicability. Transitioning to the Hindu Succession Act of 1956, we observe a significant piece of legislation that marked the transformative period in the legal landscape for Hindu succession laws. The Act brought out the revolutionary changes, especially in terms of women's right to the property, thereby strengthening their fabric, equality and justice in our society. Although our primary focus is on Hindu succession law and Indian Succession Act, it's crucial to acknowledge the unique principles of the Muslim Sharia laws as well, that plays a significant role in the succession of the inheritance for the Muslim religion. As we stand on the platform of this legal evaluation, the draft law of Uniform Civil Code in Uttarakhand presents a bold steps towards unifying the devised succession laws, aiming to harmonize the governing principle, inheritance and succession across different religions and cultures within the state. I think it's a wait and watch for time to see what the Uniform Code also talks. Today's discussion will not only enlighten us on the legal aspects but also equip us with the knowledge to navigate these challenges in succession planning in our professional role as advisors and personal endeavors. As we proceed, let us engage, question and share and food for thought with a collective wisdom that we can chart the course for a future where succession planning is just not a legal obligation but a testament to the legacy foresight. Let's embark to this journey. Please ask questions. This experience speaks a lot. I rest my speech with this and over to you. Before that, I request CA Kavita to introduce the speaker.
Thank you. So let me take a moment to introduce our speaker for the day, K. Sheshadri. K. Sheshadri is a practicing chartered accountant from 1980 in Bangalore. He's been in practice with his wife in their firm called Mrs. Sunanda and Sheshadri. The early years of practice involved a wide variety of audits, including audits of listed companies, banks and certifications of prospects. His work at present extends to advice and consultations on income tax laws, corporate taxation, which includes international taxation, valuation and transfer pricing, Service Tax, Goods and Service Tax Act, Corporate Law, Foreign Exchange Management Act, NBFC regulations and so on. The firm is consulting various clients and also which includes chartered accountants, lawyers, NGOs, cooperative societies, real estate developers. Sir is also involved in academic works such as publication of studies, reports including legal changes needed to aid and facilitate microfinance activity in India. This is a report which was issued to SIDBI. Guide to audit of microfinance sector, lessons learned from financial stock-taking exercises of NGOs in India, and accounting manuals for NGOs. So it's an honor to have you, sir. Thank you for accepting our invitation and being here. Over to you, sir. Thank you.
That the Supreme Court pronounced a judgment in the case of Vodafone. Immediately thereafter, there was a workshop which was conducted by one of the study circles, not under the auspices of the institute. And the judgment was delivered sometime on a Friday, and I think the judgment was uploaded more or less immediately, maybe in the evening. And the next day was a seminar on the workshop. The speaker was very effusive about the judgment of the Supreme Court because it had basically upheld Vodafone's plea that no TDS is to be made out of the payments which were made to the previous owner. During the tea break, a very senior CA came to me and asked me, what do you think is the shelf life of this particular judgment? I said maybe a maximum of 6 months because the budget was due it was sometime in December, so the budget was due by the 28th of February then. Only now it is shifted to 1st of February. By 28th of February, the entire judgment had been overturned. Section 9 was substituted and completely rewritten and retrospectively from 1962. Why this particular instance is relevant is because we are more or less in the same situation in this particular seminar. The issue is that you have a uniform civil code which has been introduced in Uttarakhand and it's been passed by the legislature. It's not very clear whether it has received the governor's assent. It may be open to legal challenges and it's got a long way to go. But if the present political dispensation comes back to power, say within a year's time, this particular talk will also have a shelf life of a maximum of a year because you will have substantial changes, replacement, and this, specific laws which are applicable to religions have all been dispensed with in the Uttarakhand Code. Uttarakhand Code, for example, has redefined class 1 as we understand under the Hindu Succession Act. In the case of Muslims, for example, only 1/3 can be willed, and the balance 2/3 will have to go by the legal as stated in the Sharia. Now that has also been dispensed with. So none of these specific laws will apply and only the Uniform Civil Code will apply. What you see in newspapers is only discussion on the certain social aspects which are not really relevant to us as professionals. But you don't have any exhaustive write-up on these matters, maybe because of the present election season and so on. And it's also a very long piece of legislation. Because every aspect of Indian Succession Act and various things have been incorporated there and provisions have been made. So the point is, you will have to watch out as to what happens in future, maybe in the next 6 to 7 months' time. And after a bout of challenges before the court, ultimately the matter may settle down. And you may very well have a uniform civil code, in which case the Hindu Succession Act, Indian Succession Act, as we understand this applicability to Christians or the Muslim law, all that may not be relevant at all. So this is a point to be taken note of, and maybe we'll have to revisit the entire thing by a subsequent workshop on this particular matter. Now succession is basically of two types. One is the testamentary and the other one is intestate. That is, intestate is normally where a person passes away without leaving a will. Even now if you see, this is the norm as far as India is concerned. I mean, you look back and look at your clients and find out how many people have left a will. About 10 to 15 years, in the last 15 years or so, it might be slightly better position. But in the olden days, will was never left. And there was also a mistaken notion that if you leave a will, you may pass away. And so the net result was, the man died intestate, leaving the property to be divided among the successors, and the successors had to settle the disputes and so on. Now, testamentary succession is actually what you normally understand. You leave a will, and based on the will, the succession is decided. Now, as far as the law of intestate succession is concerned, in the case of Hindus, you are governed by the Hindu Succession Act. That is, Hindu Succession Act lays down how you succeed in case of an intestate succession. That is without leaving a will. Primarily, you go through class 1 heir and class 2 heirs. Normally, with class 1 heirs, the issue will settle down. Very rarely you come to class 2 heirs. We'll come to that a bit later. In the case of Muslim laws, there are different provisions for Shias and Sunnis, but they are governed by their own personal law. Indian Succession Act applies to all others, including the Christians. This is the legal position as far as the interstate succession goes. Now, in the case of where a person is married under the Special Marriages Act, the personal law of succession will not apply. You should look at section 19 and 21 of the Indian Succession Act, and the Indian Succession Act will apply. So this is an easy solution when somebody approaches you, and especially Muslims. If they find that the succession is difficult or made impractical for whatever reason, because only 1/3 can be willed by them and the balance 2/3 goes to selected list of about 12 to 13 legal heirs. Some of them you may not will in the normal circumstances of the case. Now in such a situation, this Special Marriages Act gives you an option. In fact, I have had cases where divorces were not permitted under certain religions. So what do you do if the husband and wife want to separate? So the civil lawyer was telling me that I got them, although it was 20 years down the line after the marriage, I got them to register the marriage in the Special Marriages Act and went back to the civil court and got the divorce settled. So this is one solution in case of certain situations where you are unable to make a will or make a will of your choice. Now what happens if there are no legal heirs? This is a very interesting situation. There is a law called law of escheat. It is under the section 29 of the Hindu Succession Act and also section 34 of the Indian Succession Act. The property actually devolves on the government. There have not been recently there have not been too many cases of this nature because we have different situations altogether. The property normally gets encumbered or occupied by illegal occupants, and so matters settled down there. But if you go back and make a search in Manupatra or any other legal database, you will find some certain very old cases where it's been hotly contested. There was an Andhra Pradesh High Court judgment where the government took over the land and converted it for public use. Sometime later, the actual owner came down and said that the land is his and you cannot go up, you couldn't have taken it over at all. The government said that under the law of escheat, we have the right to possess the land. Now the law of escheat is not very simple, very easy to implement. There is a process. The government will have to ensure that the owners are identified. Then there has to be a public notification. There has to be, in earlier days you used to have the tom-tom, all around the locality to find out if there is any owner at all. So you go through elaborate processes and come to a decision whether the property is really without any owner and without any occupant, and the government can then take over. So the Andhra Pradesh High Court found in that particular case that these processes were not complete, and just an executive order has been issued, and the property was taken over, and so the property was restored to the original owner. So this particular provision is sometimes something which you should be concerned about. I think you had a case about 10 or 12 years back where there is a very prized property in St. Lawrence Road. And what happened was there used to be two elderly ladies who used to live there. One of them passed away and the other person also passed away later, and there was no occupant at all. That's a fit case where escheat can apply. So when you have a situation where there are no legal heirs, you have to ensure that a will is properly made, settled on somebody of their choice. It could be for charitable purpose, it could be to a temple, or it could be to some distant relative or friends, so that the property doesn't get devolved, taken over by the government. And another point which you should remember is when the property is taken over, the government takes it over with all the attendant obligations and liabilities which are attached to the property. It's not as if they get the property without any liability and without any obligation. Now, we'll come to the basics of will. Will is basically a legal declaration. Will and trustee have got certain similarities. they are not really agreements. In the case of trust deed also, we'll come to it a bit later. In the case of will, it is a legal declaration made by the owner of the property, and declaration is with respect to the testator's property, whatever property he owns and he controls. And it's effective only on death, which means he has a right to change the will at any point in time. Or if he has a basket of 10 properties, he could sell 2 or 3 of them, and then only the 7 may remain. Or he could have a liability which will be attached to one of these properties at a certain point in time before his passing away. And properties can also be disposed of during his life. So these are certain issues as far as the will is concerned. Now, normally there is a confusion, there is a mix-up between the word codicil and a will. Codicil is an amendment to a will. When you have to make alterations, when you have to make additions or changes, then you have a codicil. Otherwise, you execute a will. My advice always would be that whenever there are substantive changes in the form of additional properties, for example, a young executive of about 35-40 years comes to you and he wants to make out a will. When he makes a will, in the next 15-20 years you will find that substantial properties have been added on, many properties have been disposed of. Codicil is not the correct route to take. It's better for you to make a fresh will. And also he must have added on to his family, or his priorities might have changed. So these are certain things which are to be taken care of. And so execute a fresh will with a fresh schedule of properties and make it complete. See, you can intervene at any time and raise questions. There's no need to wait for the end.
What is the exact difference of codicil and the will?
Codicil is actually an amendment. It's like a partnership deed which you make and then you make an amendment deed. It's very similar to that.
So there is an original will.
Then you say that instead of then I have 4 more properties to add on, so I add that on. And I confine myself to only that particular change which I am going to incorporate. And it is not the original will itself. So the will has to be read with the codicil.
So it is like an addendum to the will.
Yes, exactly, an addendum to the will. So if the original will is registered, even the codicil has to be registered for it to be effective. But where there are substantive changes, do not opt for codicil. Make a will, fresh will.
So,
Now,
yeah. Assume under the will, there is a beneficiary for an asset. Is it obligatory on the part of the beneficiary to take it?
no.
He can say, I don't know.
But it is very unlikely that he won't take it.
Liabilities attachment are more than that.
Yeah, see, I'll come to that. See, that's a very interesting question. Now, what happens if somebody settles a property on me, say, Indiranagar Defense Colony, or Jain, I get a very priced property, but there is also a mortgage loan attached to it. Now, if the will is made in such a way that the loan accompanies the property, I have an option to refuse both. I can't say that I take the property and the debt is somebody else's baby. That cannot be done. But take another situation. There are about 10,000 shares which a testator has, say in Hindustan Lever. 5,000 shares are partly paid and the other 5,000 shares are fully paid. I can opt to take only the 5,000 shares which are fully paid and leave the partly paid shares out. So that is an option. So the point is how the will is drafted and whether the obligation is actually attached to the property and I have no option other than to take the property and the obligation. Or I can opt to take only the property and leave the obligation. Depends on the situation.
What about stamp duty, sir?
In the case of will, there is no question of stamp duty. If you want to register, you only pay about 500 rupees or so, and then whatever other charges which you pay there, compulsory, that's it. Now, registration is not compulsory. For example, a soldier who is in the war front, a young soldier, if he is in the war front, he may decide to will his property away, and then in which case it's called a privileged will. That is a will which can be executed without a signature and without even orally. For your information, Muslims can actually execute a oral will, very similar to hiba, which some of you would have handled it during your professional practice. There is an oral gift. But there are problems in this. In the case of soldiers, you are unlikely to have a problem because you will have a colleague or somebody who will testify to the fact that he executed a will. But in the case of oral wills of Muslims, it has to be established very clearly that there is no claim, there is no dispute and so on, which might be practically very difficult. this situation will come about when you want to buy, when one of your clients wants to buy this kind of a property. What is subject to HIBA? What is subject to an oral will? Those are all situations which will have to ensure that your client is protected. We had a case about, I think, 30-35 years back, where a very big property of Old Peters Road was subject to a HIBA. And so we got them to execute some kind of a document to say that they are the legal heirs and this is the position and record everything, and then the property was taken over for development. So you will have to be very cautious. Now, registration is not compulsory. I could very well have a bill which is drafted. I mean, there was a retired member of the CBDT who had a property in Richardstown, in Frasertown, a very large property. His will stated that all that belongs to me will come to my son, so-and-so, 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 signed. Now that will is equally effective, but the only difficulty is if there are claimants or if there are any interlopers. Now if there is a large property, there could be a neighbor who may be interested in the property and who may raise some issues. In those situations, you will have a problem if it is not registered or if it is not properly made. The will can be in very simple language. It can be in any language. It can be in your own handwriting, written down in a manner in which you speak. There is no technical jargon which needs to be attached to the will. Although when the lawyers draft it, like how they draft a sale deed, that entire waterways, there is no water anywhere, but the entire waterways will belong to you. All the passages will belong to you. This is how they draft the sale deed. So similarly, wills are drafted, but it's not necessary that the will should be drafted in such a manner. But one point which you should remember is will should be very clear. Now coming back to the registration is essential in case of large properties. Suppose you have about 10 acres of land somewhere, or priced lands in some of the good locations in metros. In all those situations, registration of will is absolutely essential. Unusual requests. So the Priyamvada Bella bequeathed all her properties to the CA Lodha. Now that wasn't registered and the dispute is still on. It has gone one round to the Supreme Court and come back. Arun Jaitley appeared and he is no more. So this is a position where there is a dispute. So you have to ensure that the wills are registered where there are unusual requests. We have two situations. There was a very large property which belonged to this elderly client of ours. He drafted a will and came to me and said he wanted me to witness it. But he was also expecting some kind of a professional advice. I knew that he has 3 children, that is 2 daughters and a son. And I found that he had left the son out, and only for the 2 daughters the request was made. So I asked him what is the reason for leaving out the son. He said, look, he is very well provided for, and he is from a wealthy background on his wife's side also. And the 2 daughters will require support, and that's the reason why I will get in that favor. Normally, in such circumstances, there is a paragraph needed to explain why you have left out somebody. If you don't do that, there are problems. In this situation, in this case, what happened was the will was not registered. I think it was only notarized. Much later, after he passed away, somebody wanted to buy the property, and by then the value had gone up really in Bangalore. And so the owner, the prospective buyers, wanted to confirm from me that the will was actually executed in my presence. Because the son was wondering as to how he was left out. Because there are 3 children and only the 2 persons are the beneficiaries, and the son is not a beneficiary at all. These are situations which are unusual requests, and you will have to take care that it is registered. We had another case, an extraordinarily wealthy man who left out his wife and daughter and willed it in favor of his employees, some in favor of his another charitable trust, and so on. So the point is, when I drafted the will, I made him add a para as to why the wife and the daughter were left out. For example, they were very well provided for, they were quite wealthy, and there was sufficient money which had been given to them, and so he decided to give it. But even then, it's an unusual request. If I'm worth about 5,000 crores in India and abroad, and I give away everything to all third parties and people who have met me along the way, and leave the daughter and the wife out, there is a problem. Legislation is very ideal in those cases. Do not notarize and do not leave it even just signed in witness. It's not adequate, and it will create a lot of problems at a later point in time. Now, multiple claimants and claims, for example, more than one wife or two families or PIPs, politically important persons. In all those cases, please register the will. Don't omit to ensure this, because there will be tribal claims later, and somebody will come back and say, there could be interlopers who will come back and say that he is entitled to a share in the property, and it will be very difficult to settle, and protracted litigation will start off from the lower court, it will go up to the Supreme Court. And complex assets are involved. For example, you have for example, a pending JDA. You take a typical example. There is a JDA for a large property, JDA is signed and the man passes away. So somebody has to step into his shoes. Or debts claims are being contested in the court. Or there are unusual or large amounts which are due, which the other person is reneging on payment and not accepting it at all. In all those cases, record everything properly, make proper schedule, and then get the will registered, and don't leave the will unregistered. So the ideal contents of a will is what we will go into. Describe the testator in great detail. The name, father's name and so on. Give his Aadhaar number, give his PAN number. If he's a foreigner, give his passport number. So that you have, and you give the current residence and you give the permanent residence and describe him in great detail. The legatee should also be described, and the relationship between the legatee and the testator is an essential thing. See, these are not prerequisites under the law, but these are precautions which you take to ensure that the will doesn't get questioned at a later point in time. To give you an example, in the case of a legatee, if he is an employee, for example, so you will have to describe his name, his father's name and so on, and also say that he is an employee. And he has been with me for about 35 years. So I would like to give something, and so some portion of my estate will go to him. So describe the legatee. Describe the estate very clearly. Give the schedule in complete detail. Don't say house number 242, Ulcer Road, Bangalore. That's not sufficient. Say that it's bounded on the east by something, bounded on the west, bounded on the north and south. So describe the property in great detail with a proper schedule. In the case of disputes, you specify the case number, where the dispute is, where the contest is going on, which court, and what is the amount involved, and what is the likely interest or so, whatever. You quantify at that point in time and describe it. In the case of joint development agreements and pending claims which are yet to be settled, give maximum information. Now, you also name an executor to administer the estate. Now, the executor should preferably be a lawyer, or it can be a close relative. It can even be, see, I'll give you another example. Very recently, we had a case in our office where there is a substantial property, not in Bangalore, in Delhi. Now, 1/5 of the property has been pledged to a bank. And that pledge, that mortgage itself, equitable mortgage itself is being contested. Now, when that gentleman has to leave a will, he has to ensure that this dispute is captured in the will, because he claims ownership over the entire 5 shares, whereas there is somebody else or whoever it is who has created a 1/5 interest in favor of the bank by creating the equitable mortgage. The question is, and the matter has gone into further litigation because it went to the under the Sarfasi Act and attachment and so on. So the point here is that the description of the dispute and state where the dispute lies is essential for the successors to know what action is to be initiated and for the executors to know what really happens. Now, the executor should be a capable man who should be in a position to handle the matters. If there are large properties, it should be a CA, it could be a lawyer, it could be even a relative, but preferably young, who outlives you. So if you are an 80-year-old man, I saw a document recently, he himself is about 80 and he has named as executor somebody who is 75 and who is not well enough. Now, most likely, the executor will not be there when the testator passes away, or maybe the two of them will go together. Then what happens to the settlement of the issue? That's the reason why you have to have alternate executors. Name one more. In fact, even legatees, you should have alternate legatees. Because nowadays we have smaller families. You have a father, child, mother, and maybe one child or 2 children. Now you bequeath the property to the children, and one or two of them or both of them are not around at the time, at a later point in time, then what happens to the property? So alternative legatees is a good practice. And allocation among the legatee should be absolutely clear. We had a case about 2-3 years back referred to by another CA. What happened was he used to have a property at 100 feet road in Indira, which is a very priced commercial area. Then a house or something in Jayanagar or some other area, and in another third location. Substantial properties, and he was a big man. Now the point is, he left undivided interest in each one of his properties to his 3 sons, which means permanently there is going to be a litigation on settlement of the issue. If you have 10,000 square feet of commercial area built in 100 feet road on the top floor, for example, if 1/3 is given to me, to my 2 brothers, we are going to get into a dispute at some point in time. Look at these aspects earlier and settle properly. During COVID time, all these issues became very serious because the dates were too sudden and incapacitation also took place. So in such situations, it's better to have a look at it and ensure even distribution if you want to make it even. If you want to make it uneven and favor a particular child, you give the entire 100 feet road property to that particular person and give the houses to the other 2. So that the separation and segregation is very clear. It is incorrect to presume that just because the children have lived with me during my life, they continue to live together at a later point in time. We look at large industrial families. The theory is that beyond 3 generations, they don't really work it out and they also separate. But some.
Can a beneficiary be an executor?
Beneficiary can be an executor, yeah. In fact, there are wills, but the beneficiary cannot be a witness. There are several wills. For example, I mean, if I have a house, then I will name my son as the beneficiary, name him as the executor, because there are too many properties. But if you have large parcel of properties, a lot of work might be needed. It depends on the choice, it depends on the capacity, your assessment of the capacity of the individual. If your son is capable enough, then he could be able to do it. So allocation of among the legatees should take care of the proportion which you want to divide the property among them, and also their requirements, present and even future. Take note of all these aspects, and when you get a will, if a professional opinion is sought, go through the will completely, look at all these aspects, raise questions, and get it sorted out, so that there are no problems for you to handle after the man passes away.
So, what are the remedies available to the legatee if the executor is not cooperating or not licensed?
Yes. See, then you have to go to the civil court for appointing an administrator. It's a situation which you should pray that the people don't get it, because it's a problem. The administrator could be anybody using. Normally, there is a provision that there are situations where you have what is called 2 types of legatees. The residual legatee is given the right to administer. The residual legatee is a person, that is, there are 3 children. The 3 children get all the properties in a particular way, and the 4th child gets whatever remains. Now, who has the maximum interest in ensuring that the division takes place and the succession is proper? It is a residual legatee. So the courts generally take the view that the residual legatee can be the executor in such cases. But it's a situation which you should not be caught in. Now you will have to make a very categorical assertion that there has been no coercion, there is no undue influence, and there is no. That is, he must have the capacity to contract. He must not be incapacitated. He must be in a position to speak. He must be in a position to write, unless he is a person who is illiterate, and in which case you go through with the left thumb impression. About 20 years back, we had a property in Langford Road area. Our client wanted to dispose of a large property and buy a very, very large flat in a good location there. Now the question was the title of the property. The lawyer was actually very well known to the family of the owners who gave it for development, and the developer had developed the flats. He said the original owner of the property is not normal, and the wife will execute everything or will get it executed, but this is likely to result in a serious problem later, and so do not go through with it. The client had virtually decided on the flat, and he was for it, But in spite of it, he had to drop the issue because even I advised him, because it's a very well-meaning advice coming from a very respected advocate. And so you don't go through with the purchase at all. So you will have to look at those situations. So the person must have the capacity to contract. Now what happens if you want to register and the person is unable to move? For example, he is not able to walk or wait at the registrar's office. Sub-registrar has got an arrangement under which you make an application, then they will come home, they'll send 2 representatives and see the documents, establish the credentials of the person who is executing it, and the document will be executed at home. So that possibility is also available, and aware of it when the patient, when a person is in advanced age or when he is a patient suffering from some kind of health issues. 2 witnesses are required, independent and younger in age. I have already given you an example of what happened to the case where they came back to me to check whether the will was really executed in that manner. Doctors as a witness is one of the alternatives, but I don't know. There are no family doctors now. You only have corporate hospitals.
On the witness, one caution all of us have to take is that they catch hold of somebody at the sub-registrar office, make them sign. They don't understand the seriousness of the importance of the witness.
See, just yesterday I had a document where the witness name is there along with the signature. His address is not there. That's not a bill, it's some other document. Address is not there, identification, PAN or Aadhaar, nothing is there. So if tomorrow the document is contested, what do? You cannot produce witnesses in the court. You cannot say he was a bystander who was waiting here at the bus stand at the sub-registrar's office and then got him to do it. You have to take care. You have to ensure that you take your witnesses. And now there is a procedure for photographing and putting things down in a more orderly manner. So there are those advantages you will have to avoid. Now the signature, if the person is unable to sign, then you will have to go through with the thumb impression, in which case there will be some kind of a procedure which the sub-registrar may insist on. You should, when you draft a will, please ensure that there is a residuary omnibus clause. I have 10 properties which I am able to identify. 5 of them movable, 5 of them immovable. Now I will not remember that there is a 11th property lying in my native place in which I have a child, or I have a pending insurance claim, or there is a dispute with the employer and I have to receive some kind of a gratuity from him. So cover the residuary clause with all the possible claims, all the accretions which are likely to come to the testator's benefit at a later point in time after the will is executed, and also any debts which are recoverable. If the person meets with an accident and dies, and if there is a claim which is available to you from the insurance company, that should also be covered by the will. Nowadays you find that banks and the insurance companies who are corporates, corporate entities, and who are very meticulous about some of these issues, and they just freeze your account and not move an inch unless you settle the matter through a probate or through a letter of administration, as the case may be, from the court, if there is no proper description in the will. So I
nomination facility will not work. Now we nominate, will that not work?
Yeah, I'll come to that. If you want, I'll deal with it now. You see, nomination is not a form of succession. Remember that very clearly. If you nominate your son, he is only holding it as a trustee on behalf of all the valid successors. Suppose a person has 3 children and he nominates one, say son A. Now there are B and C. The actual owners are A, B and C. So there is a very celebrated case. See, when I spoke on this topic during COVID, at that time it was through the virtual mode. I had cited the case of Shakti Yazdani. It was a Bombay High Court judgment. In that particular case, the point was there was a nomination in the case of substantial securities, and there were 7 or 8 claimants. So the case was very hotly disputed. So the person who was the nominee said that it's been nominated in my favor, and so I am the owner and I should be entitled to the benefit and the property should be conveyed to me. The matter went, Bombay High Court ruled against him. The matter went to the Supreme Court and the decision has just come out a couple of days back. I have given the reference in the presentation at a later point in time. It is a judgment which you should read. It's actually reported in Taxman. Nomination, it is actually stating a law which is well understood with lawyers and so on. Nomination is no substitute for succession laws. Succession is only through the Hindu Succession Act, the Indian Succession Act, or through the Muslim personal law.
Sir, my question was, will the bank after giving the money to the nominee saying, say, go get a successor certificate?
See, nomination is a facility which enables the company or the bank to get through with their job and continue with their operations. So I will, when you are the nominee, I will hand over the check to you. After that, it is for you to ensure proper distribution. If distribution is not done properly, the other people will raise an issue with you and they cannot involve me as a company in the dispute. This applies even to the Companies Act. I think section 76 or so of the 2013 Act and 106 and 107 of the earlier Act. In fact, that decision which I cited was under the Companies Act 1956. But if you look at the Supreme Court judgment, it's very interesting because within brackets, they mention the current provision also, which means the law which was applicable in the 1956 Act equally applies to the 2013 Act. For information, this particular legal provision applies not only to bank deposits and shares which you're familiar with, but it also applies to ownership in flats or cooperative society membership. There are a lot of case laws on this issue. Now, because that is not directly related to tax matters, we don't get to read it. But this is a stated legal position. If you read Shakti yesterday's case, which was reported in the Taxman magazine, you will have a thorough idea of what are all the precedents and how they have discussed it. In fact, in that particular judgment, one very interesting thing is, they have invoked the principle called stare decisis. That is, if you remember many years back, I think some of the older, senior people will know, the residential status, how was it determined? For 2 years he is a non-resident, then for the next 9 years, he will be considered as a resident but not ordinary resident. So the net effect of this is, 2 years I go abroad, come back, and if I have any income generated abroad, it is not brought to tax. There was some judgment of the Gujarat High Court, I think Praveen Mehta. Now in that case, the Gujarat High Court looked at this section properly and said it's got to be the other way around. Now when they back away to the Supreme Court said that no, this is not the correct view, there are other judgments and other judgments have not been looked at by the High Court and so on. Primarily, although they didn't say so, they invoked the principle of stare decisis. That is where there is a settled legal position. You don't disturb it by a new interpretation. So far, you have been going on the basis that nomination is no substitute for a valid succession through estate or intestate manner. Once that's accepted legal position, you don't bring in fresh legal arguments to neutralize this position and say that nomination is superior. If you look at section 76 or 73 of the Companies Act 2013, it will say notwithstanding any other law and so on. But that doesn't mean, the Supreme Court says that doesn't mean that nomination is superior to succession. Succession is actually the ultimate. In fact, there have been some celebrated VIP cases, which I don't want to mention the names. The son died in an accident, and the daughter thought she was entitled to the insurance proceeds. The grandmother felt that the nomination is not the issue, and I am a class 1 heir. Naturally, because she is the mother is a class 1 heir, wife is a class 1 heir, and there was a grandchild, and he is a class 1 heir too. So the matter was contested with the court, and the High Court of Delhi ruled in favor of the mother-in-law, that is a grandmother. And then she decided to part with her share to the grandchild. So this was more to neutralize and create a problem for the daughter-in-law rather than settle the issue, but this is what happened. We had another case which was personally handled by us. It was about 30 years back. A very good property off MG Road in West House Crescent. The person was quite young. He met with an accident or he died of a heart attack. And the wife was only in her 30s. And she had 2 children. So the mother-in-law contested, saying that she is entitled to an equal share as a class 1 heir. So as it's a class 1 heir, 1/4 goes to the mother-in-law, 1/4 goes to the wife, 1/4 each goes to the 2 children. And it was fought quite a bit. It went up to the High Court, and there were very good advocates on both sides. And ultimately the court decided in favor of the mother-in-law. and she took away the property, but in this case, she did not concede the property to the grandchildren or to the daughter-in-law and kept it with herself and handed it over to the other son. So these are issues. See, these are all two classic cases where interstate succession has created a problem. When you are young, it doesn't mean that you cannot go away. When you are old, it doesn't mean that you should go away. But take care. Prepare the will, ensure it is registered, and where there are multiple claimants, settle the issues even when you are alive. It's not necessary that you must make it public. See, will is a document which when you register, nobody can apply for it. It's not a public document. For example, a sale deed, if he has executed the sale deed, I can go and find out and apply for a copy. But will is not given like that. Will is given only when the person passes away. There is another interesting issue. It is not only registration. There is a process with the sub-registrar's office, which I don't recommend at all, but I'm just giving you out of academic interest, where you hand over the document of will to him, and he keeps it in safe custody. So for that, there is a provision in the Registration Act. Now, in this particular case, he keeps it in safe custody, and at the opportune time, the will is handed over. This is not a recommended practice. Maybe it was under use 50, 60 years back, when the number of properties were not too many, number of debts were not too, there were not too many issues of the nature which you have now.
Can a copy of the will can be given to the beneficiary?
Can a copy of the will?
Give to the beneficiary, saying, for me, this is what I am going to give.
To the beneficiary? Oh yes, see, I'll tell you, if you have 2, 3 children, and if it's going to be an amicable settlement, why not you hand over and keep them informed? But register and then give them the copy. See, if there is any alteration, if there is any amendment which is made by any one of the persons, then there will be issues. So don't make 3 copies of a notarized document or an unsigned document which is not registered and hand over. You can hand it over. There is no harm at all. It's a good practice. But if in the situations which I have, examples which I have given you, the testator could have never handed over the will. See, the other case which I told you where there are 2 daughters and a son, the father could have never handed over a copy of the will to the 2 daughters or to the son. Because the sons, one of the daughters was a client of ours. So she was very surprised to know that the will was only executed in favor of her and her sister and not in favor of the son, and which I was now aware of, and I had never told them, although it was 15 years before that the will was executed, and he died 15 years later. And when you get this information, ensure that it's kept confidential. That is, you will have situations where the father comes and tells you, look, I would like to give the property in favor of my first son and not to the others. If it is executed and if a copy is given to you, keep it safe. And don't give this information to the other side at all till the event takes place. Now, thumb impression is permissible in case of inability to sign. This is the same provision which you execute when you have a power of attorney, for example. You can use a thumb impression in case of inability to sign. Now, if the testator is unable to affix thumb impression, then some other person can sign on behalf. But this is actually a very difficult situation. It's not. See, some of these theoretical propositions are very nice for us to discuss, but practically they may not be capable of being implemented at all. How do you do it, and how do you ensure the validity of the thumb impression or the signature of the other person? The other example which I was telling you about, that property in Langford Town. What can you do? If there is a dispute later on, it's very difficult for you to ensure that the actual owner signed the property. It's better to sign on all pages of the will. I used to handle the tax matters of a judge of the Supreme Court who is no more now. Now, when we used to prepare the return and send it to him, those days you had the stapled returns and which were hand filed. I used to find that he would initial all pages and sign in the verification page. So one day when I asked him, he said, no, there was no substitution. It is actually a very salutary practice. You can always pull out one page, and those days it was not automized and the data was always available in a file, and anybody can take the file and substitute any page. So he used to sign initial every page and sign in the verification page. And witness cannot be a legatee, which we have already covered. Now, divorce and specification, separation, you have to specify that. As in case, for example, if there is a divorce, then what happens? Under the Hindu Succession Act, there is no problem. The divorced wife or son, husband will not get a share. But what happens if they're separated but not really divorced? And in such a situation, if the person dies intestate, he could very well come back and make a claim. We had there was a property in Whitefield. It was a very substantial property, even at that point in time. There was a very successful businessman and he had 3 daughters. Daughter 1, daughter 2, daughter 3. Daughter 3 went through a divorce. Now this daughter 3's son, a husband, was a joint owner of the Whitefield property with 2 others in the family. Now when the separation, legal separation, divorce took place, nobody remembered and nobody cared to take note of this and ensure that this is also properly separated. Much later they decided to sell the property. When they identified the buyer, then they realized that this particular man's name is one of the joint owners. So he said that you have to give me my share, otherwise I am not going to sign the document. So although he was separated from the family, he had nothing to do with the first wife and he had married again, he went through and ensured and enforced the collection of the share. So these are situations which you should remember. An auditor will normally remember and you have to take note. Will can be for a part of the property and balance can be intestate. Why would they ever do it? I don't know. But in any case, there is a provision in law for that. Nomination, no substitute for will. We have discussed it elaborately. That's the reference 157taxman.com 364. Please go through it. Life interest is another very important aspect. Now, a man has a wife and 2, say, and a son. Now, he may not want the wife to have absolute right over it and with the right to alienate. So, what he does, during the lifetime of the wife, after my passing away, during the lifetime of the wife, she has a right to enjoy the property by staying there and enjoy even the usufructs. That is, she can draw the rent and she can do anything she wants. And after her death, the property becomes an absolute owner and comes under the absolute ownership of the son, who can dispose of the property and deal with the property in any manner. So this is a law, this is an arrangement which has been made in the past and very successfully implemented. And this is a case where the registration is very compulsory because it's very unusual that you will dispose the wife of the right of alienation and will only hand over the enjoyment of the property to her. There could be various reasons for it. For example, a stepson or a second wife and an original son. There are so many unusual situations. When you look into some of these things, the relationships can be very unusual. Now, for example, you talk about live-in relationships, which in the context of our Uttarakhand code, this is an aspect which is elaborately discussed in the newspapers, and that's primary objection I think which people have, or at least the media has, for the law than looking at certain other aspects. Now, in all these relationships, executing a will, registering the property, and then ensuring that a proper segregation is absolutely essential. And in a will, certain precautions are to be taken. Describe all the immediate family members. The children, the wife, parents, everything should be described. Whoever is alive at that point in time. And revoke all the wills and also the codicils, which are very specifically by description. If you have registered the will, give the registration number and say that it's been revoked. You can say that all the previous wills executed by me is revoked. That's adequate. But I think there is a dispute which has been settled in the Supreme Court. I'm not very clear. I don't remember the citation. Where these issues came up, and it can become an area of dispute. So ensure that the revocation is very specific. And ideally, the revocation should be done in the same manner in which you have executed. To give you an example, if you look at about 20-25 years back, they will say when we both enter into an agreement to sell, I want to cancel the agreement. You take and then put 2 crosses initial there and then keep the agreement away. That's not sufficient. And that may also cause a lot of problems under the Income Tax Act if they come for a survey or research. That's a different matter. So please ensure that the cancellation and revocation is also through registration, through a registered will, in case the earlier will was registered. If the earlier will was notarized, say that and revoke it. If the earlier will was executed without an authorization and without registration, even then, you please ensure that these are referred to and specifically revoked. Now what happens if you revoke the will and then subsequently the new will which you execute also is revoked for whatever reason? If you look at certain very wealthy people, today I like you, so I will give you one share of the property. Tomorrow you have offended me, so I will leave you out and I will pick up some other friend of mine or some other person acquaintance and give him a share. In such cases, revocation of the second or third successive will does not automatically bring the earlier wills into life. This is the legal position. Now, reasons for exclusion of close family members, we have discussed it. Reasons for inclusion of unrelated persons, that's absolutely important. And describe the allocations among the legatees absolutely clearly. If there are too many properties, leave a clear schedule. Describe all the properties and give the allocations very clearly. See, when you have a doubt in drafting, make it as clear and as elaborate as possible. Do not make it, do not think that the meaning will be understood at a later point in time when the man passes away and when he may not be even our client or even we may not be around. So ensure that for posterity everything is made very clear. Do not bequeath undivided interest if it is possible. Now if you have only one property and you want to give undivided interest, there is no option. But it's always better that undivided interest is avoided because it's a source of dispute. Unusual and unequal because we have already discussed. Now there is no legal requirement that it's got to be even typed out or it should be English, but both are better options. Even if you make it in a local language, make an English translation and get it read to the person who is executing it and ensure that that is recorded and kept. Because if it goes to a court or if it goes to a, for example, the properties are all over India, and then if you execute it in Kannada or in Tamil, it may not be possible for the other person to understand. So English is one of the options which should be avoided very easily. Because for charitable religious purpose.
Can it be verbal and recorded?
No?
Can it be verbal and recorded?
See, oral will is not permitted under, except for the Muslims or in the case of the soldiers which we privileged with. Now if you oral and recorded, the recorded transaction, the recorded document will be the official document ultimately. It's not like partition. For example, you orally, it was agreed to partition the property on so and so date and now we are recording it. That kind of a document you make, but whatever is recorded will be the ultimate thing. Now, because for charitable and religious purposes permitted, if you look at the Indian Succession Act, there is a specific provision saying that this provision will not apply to Christians. The matter was contested before the court and it went up to the Supreme Court and the Supreme Court said that that particular provision is illegal. So basically this is permitted. But you should caution the client before doing it. Because charitable and religious purpose is not, charitable and religious institutions are not the most ideally managed entities. You'll have a lot of personal interest. You'll have succession and other problems there. You see across India you find various disputes here and there. So substantial properties given to them could very well get wasted away. Because to unborn persons not in existence or testator's death is void. This you should remember. See, some Indian Succession Act is very beautifully structured. Do not get frightened by the big volume which is available in the market. I think by Justice Kannan or somebody. But Bare Act is available. So only your commercial obligations and so on. If you quickly flip through, you will get a grasp of it maybe in about 2-3 sittings. If you make a 1 hour each, you will have complete control of it. When you are able to read GAR provisions, this shouldn't be difficult at all. But you will have a very clear idea of what these provisions are. Now, prior bequest to existing person followed by bequest to an unborn. See, this is called perpetuity. See, the rule of perpetuity is there both in the Transfer Property Act and in the Indian Succession Act. If you, I would request you to read the section. You can read it 10 times or 20 times. It's very difficult for you to follow. Even the examples are slightly complicated. Basically, bequest and succession do not permit a void. And they also say that before the minority, the third succession should be decided. To give you an example, A is a testator, A gives in favor of B, and after, when B's son will be given the property when he reaches the age of 25. it is an invalid request. The reason is, before he attains the age of 18, the property should be given to him. Now what happens if B doesn't have a son at all? Then from B it will go to whoever has to succeed as per his normal route of succession. So this rule in perpetuity is there even in the Transfer of Property Act. That is, there shouldn't be a void. The property cannot be left unknown and left out without any possession and ownership. He has to declare that he is in sound mind if you are witnessing or if you are going to be an executor, and ensure that this aspect is taken care of. Illiterates can also make a will subject to the proof that he must explain the contents. This is very similar to the case with other documents. In case of physical incapacity, which we have already dealt with, and the person should be a major. Now, what frequently asked questions is whether a co-partner can bequeath his undivided share in the HU. This is likely to be a very academic question if the Uniform Civil Code were to come out sometime later, because HU as a concept is not there even in the Uttarakhand Code. Now, Section 30 of the HS Act, Hindu Succession Act permits it. But does he become a co-partner when you bequeath? He doesn't become a co-partner. He has only right to the property. This which you should remember. But what will really happen is you are creating a third-party interest, which is likely to create a lot of problems for the existing members. This is normally done to harm the existing members. Otherwise, it serves no purpose at all. Now, tenancy can be gifted, can be willed if it is subject to the rent control law and lease deed. This was a problem only in Bombay, not in places like Bangalore. That's why if you see in Bombay now, you have only what's called the legal license agreement, which is for a period of 11 months, and then it's got to be renewed. And if you look at the agreements, tenancy agreements drafted by those lawyers in Bombay, you will find very important clauses which are incorporated there to ensure that many of these things don't take place at all. And it should be his own property. That's very important. Now, executors, who should be the executor? He should be a person well known to the legatee and to the testator. His consent is very essential. He should be preferably young and should preferably be a professional or a relative who is well versed in the ways of the world. Not necessarily legally instructed. It doesn't really matter if the person is not a lawyer or if he is not a CA. It's quite okay if he can always take outside him. But the point is, he should be prepared to act and prepared to take decisions. You can have situations where the children may not get along well, then he must be capable of resolving the issue. Now, letter of administration, if no executor is appointed in the will, then you have no option other than to get a letter of administration from the court. You can have situations where the executor dies, so you don't have an alternate executor. Then, or legal incapacity and refusal of the executor to act. Say, normally if you look at the wills, the executor will be paid a remuneration of 10,000 rupees. 10,000 is a normal norm now. But actually the work involved can be much, much more. And who will act for 10,000 rupees? You would rather opt out. Then you have to go to the court and get a letter of administration. And letter of administration, as I told you earlier, is either granted to the universal or to the resident, normally to the resident legatee. As far as the Muslims are concerned, only 1/3 of the property can be willed. Now, this is considered as a disadvantage to the Muslim law, in the sense that only I have a right to will only 1/3, and the balance 2/3 has to necessarily go to the legal heirs. But this had a purpose. They didn't want a situation where the entire property goes to non-relatives or to unrelated persons. It was a safeguard. So they said 1/3 you can do what you want to will, but the balance 2/3 has got to go to the relatives. Now the present problem is, who are the relatives? It includes so many people. It's very similar to a class 1 has list. So that is where the problem comes up. So what is normally done is to create a trust, and in certain cases you gift the property even when you are there, trusting the children to take care of you if it is required, and get along and avoid this possibility later. Now, the balance will pass as per the personal law. I am not getting into the list of relatives because it's, you can look up the book at any point in time, and even if I have to tell you now, I'll have to look at the book. Now, oral will is permissible, but there has to be, you have to establish the fact that there is no coercion and no undue influence. This is a very important aspect. Excess over 1/3 can be by the consent of legal heirs. Suppose I have 5 legal heirs and 1/3 I gift, and then I want to give something more than 1/3, the 5 of them have got a consent. Now imagine a situation out of 5 only 1 consents and the other 4 doesn't consent. His share shrinks and the others get their share protected. Now if there are no legal heirs, what will happen? Then bequest of whole property is permissible. Because otherwise by escheat, the property will vest in the government. So that's why this provision is there. In the case of Muslims, please ensure that you contact some advocate who is well versed in the Islamic law and get it vetted. In fact, preferably drafted by him, and then you look into it in any case all over again and run through it. Because there are different denominations, and so there are slight variations between the Shias and the Sunnis as far as the succession is concerned. Now, probate. Very frequently you will be asked as to why, whether a probate is required. Probate is actually required only in 3 cities, that is Calcutta, Madras, Chennai and Bombay, because they were earlier presidency towns. And it covers even properties which are located there. This is a point you should have to remember. Now, probate is granted only in case of testamentary succession. So, I don't know how many of you have had opportunity to look at a probate. Because unless you have a client who has a property in Madras and who has produced a probate to you, that is, bill copy is handed over to the court, and the court looks at it and then passes an order. It's a part of the bill is a part of that order, and a fee is collected. There is a court fee to be paid. In Karnataka, I think it's about 75,000 rupees is the maximum. In Maharashtra, it's about 30,000 rupees. Now the court certifies a copy of the bill. So the conclusiveness and validity of the will is established. So you are more or less safe, because it's a procedure for public advertisement, inviting objections, and then deciding on whether the probate is to be given or not.
Here, probate, do we have to put a paper publication for each and every property?
Not each property. You will say the so-and-so has applied for a probate, and then with regard to various properties, and see they also paste it, I think, outside in the court, seeking a job. You try to get a copy of the probate executed somewhere. It's very instructive, actually. It's a very simple document, hardly about 3-4 pages, that's all. And another point is, probate is granted to the executor, because he is the person who is executing the will. Probate is not granted in favor of the beneficiaries. The executor applies for the probate and he gets a probate. Now, succession certificate is an alternate, sort of an alternate to probate. Actually, if you read the Indian Succession Act, succession certificate is issued by the court for intestate succession only to recover debts. It doesn't talk of immovable properties. But what do you do in case there is a what do you do? See, we had very recently a case where a substantial property was to be transferred after the father passed away. There were 2 children and a mother. Now, in this particular case, the successors were only 3, but the father had not left a will. But the property was very substantial, and the buyer was willing to take it. Now, how do you establish the ownership? Actually speaking, you have to get a succession certificate and produce that to establish that these are the 3 people. Now we have a document called legal heirship certificate, which all of you would have come across. As far as Karnataka is concerned, legal heirship certificate is not really legal, but it is still issued by the Tahsildar. And that document is taken by people to transact on properties, but where there are substantial properties involved, it's better not to trust that, rather than go through the court process and get a proper document to substantiate who the successors are, and then only buy the property. Privileged wills I have already dealt with. It can be oral, it can be unsigned, it can be unattested. For example, he is shot, he may not be able to do anything beyond telling him orally that all the properties have to go to my wife and child. Now, joint will, See, joint wills are all not recommended, but these are all very theoretical aspects which I'm just discussing. It is made by two or more testators in a single document, disposing of the joint or separate property to the same or different legatees. Husband and wife, for example, they could do that. Joint wills are revocable by each of the testator or even by the survivor. See, these are all invitation for practical problems. Please ensure that separate wills and proper execution takes place. Mutual wills, that is, I confer benefits on you and you confer reciprocally benefits on me. That is another aspect. That's another thing which can be avoided. Mutual wills are revocable if both testators are there. Onerous bequest is one with obligation which we have discussed. That is a property with a liability. Revocation of wills are to be revoked following the same procedure as execution. You should not cross and put an arbitration and be done with the will. Rule against perpetuity, we have already discussed section 114 of the Indian Succession Act. Basically, 114 prevents creation of remote and uncertain future interests and lays down timetables. This is the purpose of 114. Now, there are certain FEMA implications. Can an NRA or OCI acquire removables in India by inheritance from non-residents? It is possible if the non-resident's acquisition is as per FEMA, or when a non-resident has acquired the property from a resident. The NRA can inherit from a resident, which is provided for under section 6.5 of the FEMA. You need not look at the capital account regulations or the non-debt instrument rules and so on. Whenever you have a doubt, first look at section 6. Section 6 is a very important document. For example, if I've gone abroad and I have earned money and I've created a bank deposit there, now I come back to India and become a resident, I'm allowed to hold that account. If you look at section 6, section 6 and 5, 6.5 and 6.6 will deal with both situations, residents and non-residents. So the account is legal because of a specific provision there. Now, wills are not without limitations. First limitation is litigation, fragmentation of asset. Now, I have a 300-acre land, and then third or fourth generation will get 5 acres each, or maybe 1 acre each, and nothing can be done out of it. Variations in market value is a very serious problem. It can be changed and revoked. So if there is an elderly man, see, I had a case of a very close friend of mine, whose father-in-law had, in a pick, decided that a property in Indiranagar will not be given to his daughter, and he went and sold it to a particular, another relative of his, got some money from him, with a sale deed saying that as long as he and his wife are alive, the property will be, he will enjoy the rights of the property, and after that it will go to him. So the property was lost forever as far as the son-in-law and the daughter are concerned. So this changing and revocation, especially in case of people who are temperamental and who are short-tempered, there is a problem. Ring fencing of assets is not possible in the life of the testator. That is, you cannot protect the asset. If I am running a startup which goes bust, as is normally the case, after about 10 years or 12 years, depending on the product and depending on who the investors are, then how do I ring fence the asset? My children will not have any right over the property. You look at many of the startups, what happens to the successors, and they are pretty young when this happens. That's the reason why you find people who are very wealthy, who are industrialists, they have home office. That is, they have private limited companies which are set up and which manage assets. Or they set up a trust and put their family members as trustees and beneficiaries, and that is completely separate. Now, probate is another issue, especially if you have in the 3 metros. This actually concludes the presentation on wills. Now we go.
Will is there unregistered and no dispute anything. Now in 2 cases, shares and property. Will the registrar in case of shares and sub-registrar in case of property will accept the will, unregistered will, and transfer, no issues in that?
See, you don't go to the sub-registrar. If you have an unregistered will, you go to the company if you have shares, and the company will register it. If it is a property, you go to the corporation and change the Kata. Kata is not the ownership document, but that is where the property changes take place. Sub-registrar's document will continue to show the earlier name. Okay. Suppose it is your father or grandfather. When a subsequent sale takes place, The buyer will take care of this and then examine the will and then execute the thing in his name. If you go and take an encumbrance certificate, successions will not be recorded there. Even if you register a will, the succession will not be recorded in the encumbrance certificate. But transfers are not a problem as long as there is no contest and the property is clear. For example, a BDA registered in a BDA plot which is allotted, you shouldn't have a problem with a simple will which is even unregistered.
No, isn't it strange that the sub-registrar will continue to show for 50 years the old passed off person?
Yes. Yes.
So if there's
Sir, in
can
case-
an unregistered will succeed a registered will? Like when we click at the end.
That is first I register and later I could do that. Only thing is you have to revoke it, but it will lead to a lot of disputes. See, first will I have registered. Why would I ever make an unregistered will? Unless, for example, I am very sick and I am unable to move around, or I have a specific reason. Deathbed, for example, those are situations. But otherwise, see, unusual transactions you always watch out, take care. See, sub-registrar is not, he is only recording transfers and transactions which are taking place in the property. So otherwise he will not do anything.
Sir, in case of market value valuation, in one of the cases, in my client case, the estate and what she has done is she's got a property and she had, estimated the value and mentioned the value of the property at the time of registering the will. And when she passed away, the value was much more. And how do you distribute it?
No, that's not relevant at all. What she is billing you is actually the property.
Okay.
So, if I make a bill in 1950 of a property in Mahatma Gandhi Road, it could have been only 5,000 rupees. Now it may be 500 crores. That's completely irrelevant. And there is no stamp duty implication either on succession or at the time of execution of the will. So that is not an issue.
But if she had detailed it, like who should get how much, then
Well,
how do we distribute the balance?
See, if she has mentioned that 1/3 has to go to all the 3 people, and these are the properties, and this is the present market value, that will be a real problem, and you will have to settle it and distribute it accordingly. But very unusual that somebody will do that. See, if there is a property in MG Road and the value was 10,000, and then now it is 500 crores. If I say that all my properties will be divided equally 1/3, 1/3, 1/3, then you will have to go by the market value and distribute it.
But if she has mentioned the value, like somebody will get 10 lakhs.
Value is not the issue. It's actually, even if she mentions 1/3 each, that's bad enough,
Sir, in case of a joint shareholder, joint shares, equity shares, joint holders are there, I think it overrides the will. That is the joint transmission. Basically, the transmission overrides.
No, the transmission will not be overridden by the joint will. See, the case of articles of associations will normally say that the second holder will operate.
Yeah.
That is between the company and you. See, that's probably between the company and you. You should remember one thing, nomination, articles of association, all these provisions are only to facilitate commercial transactions going on smoothly. See, if I am a bank or if I am a company, there is a dispute, then who do I pay the dividend to? And after a certain period, I have to transfer to unpaid dividend account and hand it over to the government. So to resolve all those issues, the government says that you nominate or you have a joint arrangement, then the second fellow will automatically take over. But otherwise, in case of succession, you will not be able to use that argument. See, he may very well, jointness may be in the form of 50% each, for example. How will you know? And if it's a substantive value, it's very difficult that one person will automatically get it. Even if the articles of association contain that kind of a provision.
Property in Bangalore, probate is necessary. Property in Bangalore, does the legal have to get a probate?
You can get a probate, yes.
So is it necessary compulsory?
Well, in case of interstate succession where there is a substantial property without will, for example, the other property which was mentioned about in the Rest House Crescent, in that particular case we got a probate because otherwise development and subsequent sale wouldn't have been possible at all. There is no bar in applying for probate in any other city, but probate is compulsory in those 3 cities.
Is an unregistered will. How does if it's contested, how is the forensic procedure?
Well, the person is dead, but you have 2 witnesses. But if the witnesses are like what he said, without name and address and so on, they may not come at all, or they may refuse to come at the course. Then the executor is there. See, there is a Supreme Court judgment on the issue. There were some alterations. It's an excellent judgment. Unfortunately, I don't remember the citation. It is a process. It is a bill which has created a lot of problems, and it's been sorted out by the court. And they have found that the bill is not genuine. Obliteration, for example, or inconsistencies, or the language, for example. See, the person is only say he's not very well versed in English, but it's drafted. First will is registered, second will is unregistered, and it's drafted in excellent English. Those are all attendant circumstances will be taken into account, surrounding circumstances will be taken into account to decide the validity. But it will result in a lot of dispute, and in case of substantial properties, a matter will reach the Supreme Court.
Just the forensic report will help.
Forensic report will help in case of illicit cases. But what happens is, we have actually done it for some other purpose, not in the case of will. There used to be a handwriting expert in Rajajanakar. If I sign my name Sheshadri and hand it over, and you have another 2 other signatures of Sheshadri, then you give it to her. They have to choose a science actually. They will be in a position to find out whether it's the same person who has signed both, and they will give you elaborate, clear legal explanations. So in this particular case, the president of the NGO said that he has not signed it. So when the overseas donor came to me, then I took them to that Rajajanagar, that lady. This was about late 90s, and we got a certificate from her to establish that he was a fellow who signed all the documents. So you can establish. There are handwriting experts, and in fact, the government of Karnataka, each state government has got one handwriting expert department. It's actually on, I think, on Palace Road. So in fact, the courts will refer matters to those experts to get an official confirmation of what the position is.
So can the unsecured loan be recovered from the property which has been given in the will? Suppose a person has taken an unsecured loan. And also
if it is attached to the will, see, there are 2 issues. If I am a successor, if it is an unsecured loan, then the loan will be recoverable from me to the extent of the property. It's got nothing to do with succession, but it's a normal common law. Now, if the property is attached with the unsecured loan, then I have no option. I take both, and I cannot give up on the unsecured loan. So they can very well see. Look at income tax, for example. To the extent of the property which is available, they will be in a position to recover it even from the successors. Guarantees you should be very careful about in the light of the recent Supreme Court judgment and so on. Now, as far as private trust is concerned, it's actually an obligation annexed to the ownership of a property. You have an author who actually reposes and declares a confidence. In whom does he declare the confidence? In the trustees. And about what? About a property. And for the beneficiaries. These are the 3 aspects which are taken care of, which are to be taken care of in the case of a private trust. Private trust is a very odd structure. There are 2 owners. You talk about the Binami Act, where 2 ownership is not really possible. But in this case, private trust, the beneficiary is actually the beneficial owner. The legal owner is the trustee. So if the property is given to the trust and the trustees are managing it, the trustees will have a right to sell, will have a right to do things for the benefit of the beneficiaries. But the beneficiary is actually the beneficial owner. The benefit of the sale process will have to come to him. Now in this particular situation, if the trustees mismanage or if they create a problem, then you will have difficulty in trust. This is a fundamental disadvantage in case of trust. Do not create trust in favor of children when you can resolve the issues when you are there and settle and ensure that you separate the property and segregate and be done with it. Trustees are basically third parties. They may lose interest or they may have personal requirements or personal preferences. Those are all certain problems which will arise. So that's a major disadvantage as long as trusts are concerned. And trusts are basically a good form of succession only if there is a substantive property. If the properties are not substantial, will is a better option. And the author of the trust can also be a beneficiary. Now, why do you normally have trusts? Protection against insolvency and business failures. You look at the IB code, there is a specific provision for action against officers where the property has been transferred within a 12-month time gap. And then Transfer Property Act and the Companies Act section, I think 447. I don't know, I'm not able to recall the section repeatedly. Section 447. So it comes sometime later. So 447 is actually a very serious provision where for frauds action can be initiated. You find in papers periodically that 447 action is taken. We normally read the news item in Times of India and then keep it away. But please go to 447 and find out whether you'll ever form a company and be a director. Its consequences are very serious and threshold limit is very low. And a lot of action has been initiated by the registrar. I think even recently, I think there was a case which was argued where the Kerala Chief Minister's daughter's case. See, they ordered initially an inspection, now they have initiated under 447. The argument before the Karnataka High Court, I think the decision is actually reported, was that 447 action could have been initiated when there is an inquiry going on, inspection is going on. But the court did not accept that argument. Those are all, and the amount was very, amount as reported is not very large. So these are all certain issues which you have to take care. Now, differently able and incapacitated children. You have certain outfits of Coimbatore which take care of children's interests. When they, for example, if he has autism or if he has certain serious health issues, what will you do as a parent? So you create a trust and they have a particular scheme which they go through with and ensure that the property is secured for him. And they take care of the management of the property and ensure that the benefits go to the children later on. Protection of traditional family businesses. I have a large trading organization and I cannot distribute it as one-third everybody. And I may have children who may not be really interested in running the business. In such cases, I settle everything on the trust and ensure that the property, only the benefits go to the beneficiaries rather than dividing the business itself. Ease of governance and low regulation. Because trust is formed in a single document. Once you're very clear on the contents, you can go to the sub register and register it. If it is immovable property, then compulsorily it has to be registered. If it is movable property, registration is not required, but registration is better. Now, no probate. So he was asked, there is no need for a probate at all. In the case of Muslims, trust is one of the options because of the restrictions of wills. Now, inheritance tax abroad also has resulted in creation of trust. And then there are perceived tax benefits treated. Trust is not an ideal form of tax saving measure as it was about 20-30 years back. Now we have all kinds of problems. MMR applies when there is a business and discretionary trusts are subject to MMR. Those are all certain problems. So it is not a very ideal tax saving option. That's why I call it as perceived tax benefits. And the control is vested with the trustees who are normally former family members. Now there are different types of trust. One is a discretionary trust. I as a trustee will have absolute right to decide how much which beneficiary will get, at what point of time he will get. These will result in tax litigation. One big case which went up to the Supreme Court is Gaikwad family. The discretion was never exercised and so the question was the taxation. So that's a very, it's an old case, maybe 10-15 years, but it's a good case. And Kamalini Katav is another case which you should look at. And there is no stamp duty in the case of trust because there is no transfer. In the case of discretionary trust by will, there is no stamp duty. That is, in the will you create a trust for the benefit of the beneficiaries. Now will has no stamp duty, there is no stamp duty here also because succession takes place only after the death of the testator. Whereas if you form a trust and settle the property in the trust, then there is a need for registration. Now it is taxed as an AOP under 164. Whoever has the patience and the need, please go through section 160 to 165, 166. In fact, there's a very interesting provision. Non-residence agent, that's something which you will have to read and even as professionals we should be very careful about it. Now, distribution at the discretion of the trustee is based on the needs of beneficiaries, which means the trustee should be absolutely reliable and honest and should not discriminate between one beneficiary and the other. Now, revocable trust is normally not done because section 64 will operate, clubbing provisions will apply. Because when you have a right to revoke, then you are really retaining the control. And so the income is mine. I just make it believe that the beneficiaries are actually the income owners. Now, what is revocation that is described in section 63? Please read the section very carefully. Provision for retransfer of income or asset is very clear. Right of resumption of power over income or asset. And transfer includes any arrangement and agreement, any alienation, any gifting, everything. So if I say that the property is settled on the trust, but out of that about 1 lakh will come back to me every month, or 1 lakh will come back to me after 2 years, then that could be considered as a revocable trust under section 63, and so the clubbing provisions will apply, and it will be of no effect. Any trust which is done is normally irrevocable and settled back more or less permanently. Now, the longevity of the trust, how long should it exist, even if it is irrevocable? If its purpose is served, then you can very well wind down the trust. For example, we had a case where the property was a very prized property in Nanjadurg Road, and the father settled it in favor of the daughter-in-law and the two children and the grandson. Now, the granddaughter was not given a share because he thought that in any case, once she is married, her interests are taken care of. Later, after the passing away of the father and the grandfather, when this property had to be sold away, the problem arose as to what should be the capital gains impact. So ultimately, our suggestion was you make it 1/3, 1/3. They wanted to give the daughter also a share. So there are registration took place in favor of these 3 people by paying the stamp duty at the current market value, and then the sale took place. So double stage, but there was an advantage. 3 capital gains, 3 investments, 354. Those are certain advantages. Now, discretionary trust we have discussed. Determinate trust is the settler normally says that each beneficiary can get a certain percentage, or it could be by a formula also. It's not necessary that it has to be by a percentage. And there are no discretions given to the trustees at all. Irrevocable trust we have dealt with. Now, what should the trustee look like? It will have a name. It should spell out the intentions of the settler very clearly. Unequivocal declaration is very essential. You should part with the property. You can't create a doubt whether the property will go or not. And then the purpose should be very clear. Is it for taking care of the children's education or their marriage or whatever you want to mention? The trust property should be described, beneficiary should be described. If you look at these requirements, they are very similar to what you do in the case of a will. Make the description very clear, give all the information and details. The intention to part with the property is very, very essential. Then who can create? Anybody who is completed the contract. A minor can also create. You look at section 7 of the Indian Trust Act. It says that you can create a trust by or on behalf of a minor with court permission. When it can arise, for example, minor is an orphan. He has lost his parents and there is nobody to take care. Or he has lost his parents and he has ended up with a huge bequest. Then what do you do? Now, term of the trust you have to mention, particulars of the trustees. Choice of the trustees is very, very important. Take care. It is not as simple as that of an executor. Executor has no right over the property. He can also mismanage. We have had a case in Bangalore where a particular executor was actually disbarred by the Bar Council because of misapplication of the properties some years back.
Sir, what about corporate trustees for a paid service?
That is corporate trustees, isn't it? Now I have actually dealt with it somewhere down the line. We suggest that you have mentors to follow up on what they are doing. See, for example, banks are trustees.
Yes.
In such cases, you will find that one professional is managing and after that he gets transferred, somebody else takes over. So there is a need for some kind of a mentor to keep a watch on what is happening. That is permitted. I think Kotak Bank and several other banks have this kind of an arrangement. Never make any document, whether it's a partnership or a will or a trust deed, without any flexibility. Don't make it inflexible. For example, we had very recently a case of a high-profile trust, a charitable trust, which says that no trustee can hold an office beyond 2 terms. Now, if the trust gets into difficulty, And if nobody is prepared to take it, hold they can, then what do you do? So never make it inflexible. Ensure that this kind of things are sorted out right at the beginning at the time of drafting. Provide for resignation. Now what happens if all the trustees resign? Then you have to go to the court and get somebody nominated through the court mechanism. And ensure that people are interested in managing the trust. So the point is, assessment of the trustees' individual capacity, character, and the reliability, the relationship with the beneficiaries are all important for you to decide. Dispute resolution, there has to be a specific clause. Subsequently, I have dealt with it. Arbitration will not apply to trust because it's not an agreement. If you if you look at the Arbitration Act, there is a Supreme Court decision on the issue. If you look at the Arbitration Act, there has to be an agreement compulsorily for Arbitration Act to apply. Now, the Supreme Court says that trust or will, etc. are not an agreement. In the case of a trust, the beneficiary doesn't sign. It's only the trustee and the settlor who signs. Now, dissolution, amendment, provide for everything. And when your client has got specific requirements and specific problems, take note of it and provide for that also. Register the document. In case of removals, it's got to be compulsory registered subject to stamp duty. Now, tax benefit versus loss of control over the property. See, the present situations, there are too many separations in marriages. You find that the people exit very quickly. In such situations, if the husband or the wife, whoever it is, settles the property in the name for trust and makes it irrevocable, and after that the separation takes place, he or she will be left in the lurch because the property has gone to the trust for the benefit of somebody and you have no control over the property. So there is a need to assess the requirements of the specific situation. Young people, you have to be very cautious and find out and make an assessment and talk to them before suggesting also. Business through trust. If you really look at Section 20 of the Indian Trust Act, investment in this kind of business is not permitted because it's not only the mode of investments, but business is being carried on. The only problem is tax at MMR. Then clubbing provisions are to be considered. Trustees should be capable and reliable, and discretionary trusts are not a reliable option. The decision whether to have a trust or not, or only to go through the will route, or do nothing and ensure that the shares are transferred to the successors, all these decisions will have to be taken by the client. You only give the pros and cons and leave it at that and push it to a particular decision. Don't suggest that this is the best alternative and you ask him to go ahead, because later on you don't know what will be the turn of things. Now the stamp duty implications, I told you, a subsequent dissolution of the trust which resulted in stamp duty outflow. Now fraudulent transfer under tax and insolvency laws, we have actually already covered it. That is Section 437 of the Companies Act, IB Code, Transfer Property Act and so on. Now will is preferable for young settlers because of family discord. If there is a family discord, trust is an irretrievable situation, whereas will is revocable and you can go back. But there is also the other side. If the person is in a very risky business, then what happens if there is only a will and he loses the property? So trust might be a better option. So you'll have to look at pros and cons and come to a position. There are certain practices which are followed. There is a main trust and then there are sub-trusts. So the sub-trusts control various businesses and these businesses are given to specific children, and the main trust is a controlling body, some kind of a holding company. These are all very complex arrangements, but they are made. Multiple trusts are created for multiple business units. This is also possible. Large institutional trustees which he was referring to, with portfolio managers and advisors, but normally mentors are to be appointed to oversee what they do, because you've got to ensure that decisions are taken correctly for the benefit of the trust, the beneficiaries. Now you'll also have to look at tax on gifts and donations. Section 56, in case of relatives, the trust is, if you create a trust for relatives as defined under Section 56(2)(7) explanation, there is no difficulty. But be careful of the list of relatives. Even if you are absolutely familiar with the section, read it again before you go through it, because it gets periodically amended. And it looks on a reading that only one-way relationship is covered. If you really look at the last subclause, it says that from a member of the HUF family. So HUF to member is a cover, is a question. Member to the HUF is covered. So recently we had a case where the mother, who was not a member of the HUF, was involved in the gifting, and 56(2)(10) was applied. So be careful of the relatives. And relative differentiation does not include several relatives whom we would accept normally as relatives.
What about the stamp duty rate for the trust?
See, if you are settling in immovable property, it will be like conveyancing. See, if it is a mobile property, then in the current Karnataka Stamp Act, I think some kind of amendments have been made.
But it is lesser paid in case of immovable property than we have to pay it at the time of execution.
Can you repeat the question?
It is paid lesser for an immovable property, undervalued basically. In that case, it has to be paid at the time of execution.
No, if you undervalue, he will hold up the document, no? He won't give you the document at all. See, it's like conveyance. If you settle a property, immovable property and a trust, when you go to the sub-registrar, if it is below the guideline value, he won't release the document to you. Unless you have a valuation issue, you are going to contest it and so on, go to the district registrar, appeal and so on. Otherwise,
but when you are transferring the property to a trust, it becomes a transfer and the income tax capital gain will come up there.
no,
But for a trust, will it be considered as an income?
no, that's what. 56(2)(10) says that trust in favor of relatives, there is no income tax in the hands of the trust if the trust is for relatives. Relatives as defined in section 56(2)(7) explanation. Now 56(2)(10) it's dealt with here. It accepts receipts by trust from individuals. This is your question. Now provided the trust is created solely for the benefit of the relative or the individual. Relative is defined in that section 56(2)(7). And you have to be very cautious of the definition of the relative. Look at it before exercising the option. Now as far as income tax is concerned, there are a lot of complexities. The trustee is treated as a representative assessee under 161(4) and under 162. Now, a representative assessee is treated as a beneficial recipient of income for purposes of Income Tax Act. He is deemed to be a beneficial recipient. So, an MMR is applied for the whole income if there is a business income. In the case of a trust which is created by will and which is the only trust which you have created and which is for the benefit of a relative, then MMR will not apply. See, these provisions you go through and also see the circulars on the issue which the CBDT has issued to understand. And there are enough case laws. In fact, there is one particular case law which I deal with a bit later. Now, representatives, assessees have the right to recover and retain from the beneficiaries in case they have given any money. Now, if the trust gets into a very bad situation, especially tax litigation, there is a problem. What happens if you look at section 161, 160 subsection 1 and so on, it says it will be recovered in the like manner and in the same amount and proportion as it is recovered from the beneficiaries. Now, are the trustees also liable to pay personally in case there is a tax demand? There are no provisions similar to private limited companies, LLPs or partnership firms under the Income Tax Act to recover from the individual directors if there is any misfeasance from them, or in the case of LLP, such provisions are there. But in the case of these trusts, such provisions are not there. But this is an area of dispute. This is one reason why professionals should not be trustees. Don't take up all that work. We have enough problems of our own. So the representative's right to recover under section 162 may be a non-starter, because if you are in that kind of a position, the trust will have no money. And when the trust has no money, you are responsible. And that is an issue. In the case of MMR, in the case of discretionary trust, we have already discussed, it's subject to MMR, subject to those exceptions, that is through the will and for a single trust, for a dependent beneficiary. Now these are certain very interesting cases. Arbitration is inapplicable and disputes are to be settled through civil courts. So in the case of a trust, if there is a dispute, or in the case of a will, if there is a dispute, you will get into a long winding dispute, and you will go through from the lower court, you will go till the end, depending on the volume and value of the property. Fraudulent and willful parting of property, please see section 68 of the Agri Code. It's a long list of items. It's very interesting and instructive to read. Section 447, it's a must read because amendment is covered, and you could have situations where auditors get into trouble also. Please look at it. Section 53(1) of the TP Act, that is Transfer Property Act, for fraudulent transfer. And 281, which all of us are familiar with, that is tax recovery officer issues a attachment order or recovery certificate on account of a proceeding which is going on. Then you cannot, anybody who acquires a property, the transaction will not be valid. Unless he has paid valid consideration, he was not aware of the dispute. This is the reason why you find that when big properties which come up for development, the developers' lawyers normally insist on a clearance certificate under 281 from the ITU assessing the seller to ensure that there are no claims under the provision. Now, Shriram Ownership Trust is a very recent decision, 2021 decision. It's a good, very good decision. It's a Madras High Court decision. What really happened was Shriram is a big company. They formed a trust which was for the benefit of the senior individual employees and some directors. So they transferred the corpus of about 25 crores from a clutch of companies in which these people are employed into the trust. And the arrangement was that this 25 crores will be there, income will be earned, one portion will be used for charitable purpose, and the rest of the money will get distributed among these employees at a certain point in time. For example, when they reach superannuation. The department said the transfer of the corpus to this kind of a trust is taxable. And that became it's a very hotly argued case. And the High Court decided in favor of the department, saying that the corpus is actually taxable because of the peculiar circumstances obtaining in that particular case. In the context of charitable trusts, there are decisions which say that corpus is a capital receipt even if it does not enjoy registration at 12A. That is a different matter altogether, but this is actually an issue. Then Vimal Kishore Shah versus Jayesh Shah. This is the case with respect to arbitration. So that's the end of the program.
What about settlement deeds?
Settlement deed is normally done only when there is, among family members, if there is a dispute. One fundamental prerequisite of a settlement is actually a pre-existing dispute or a claimant. I'll give you an example. We had a case of a person who was married and he had children. He is very, very old. Even the children are very old. Now he had two wives, and first wife had children, second wife had children. Now the second wife children claimed a share in the property of the father who had passed away. It was contested, and ultimately it was settled through the court process, through a settlement deed. Here, the second wife's children had some kind of a right over the property. Now you cannot sort out problems through settlement deed where there is no pre-existing claim or pre-existing dispute.
Compared to will, is the settlement deed not better?
No, it is not a substitute. That's what I am trying to tell you. So if there is a pre-existing right or a pre-existing dispute, in the case of will, neither exists. I own the property, I will the property in favor of three of my children. They have no right over my property. If they had right over the property, I couldn't have willed it either. Now, if there is a joint property, I have acquired the property through my grandfather or father or whoever, and the children feel that they have a share in the property, then if there is a dispute, settlement deed is issued. There is a very good Madras High Court judgment. If I remember the name, I'll tell you. But there is a Karnataka High Court judgment which is very brief, Nagaraj. You can actually go through taxman and get it. But the Madras High Court judgment is more instructive. Mr. Sarangan appeared, and it's a very elaborately argued matter, and it's an excellent judgment actually. So do not suggest settlement deeds unless there is a dispute which you can establish. Don't exchange a few letters and say that there was a dispute.
No, the settlement deeds also gets registered.
It could get registered, but under the Income Tax Act, for it to not to suffer consequences of capital gains and transfers and so on, these two requisites are to be met. Settlement is of a dispute or some kind of a vague claim.
Because wills are contestable, settlement deeds.
Why it cannot be contested? The department, income tax department will contest it. That is more than sufficient for you.
No, in case of family
Yes.
disputes,
After the will or without the will.
when you compare the family
Oh yes,
disputes,
oh yes. That what you are saying is right. That is, there is no will or there is a will and there is a dispute. You could very well enter into a settlement deed and divide the property even unequally. Because in those cases,
the authority has got right in every aspect. When a statutory authority comes or government comes. But internally, when the family is concerned, settlement deed is a better document than will. That's what I think so.
no, settlement deed is not a better document than will because you will have to go through the process. See, will, why
Because
would
the
you?
settlement deeds is that the people who are involved in the document, they also are a signatory to the settlement for acceptance of the.
See, why would you do that if there is a will already?
Sorry.
Why would you do that if there is a will already? If there is no will, you
No, instead of will, they do a settlement.
yeah, intestate succession you can do a settlement deed. That's okay. It can even be unequal.
Yeah, because all the people who are involved in it, they are signatory to it.
Not only that, settlement of dispute is considered to be an adequate consideration.
No, I think he is talking about settlement during the lifetime of the
Lifetime of the
testament.
deed.
During the lifetime,
Lifetime of the testament.
why it cannot be treated as transfer, right? There is a Bombay High Court judgment which is, you please go through that, where they have settled it during the lifetime, shares were distributed and it was held to be liable for capital gains. You should be very careful. See,
No, the effect of the settlement will take place post the demise of the settler.
No. Then it is not a settlement.
So you said as far as Muslim law is concerned, only 1/3 can be will. It applies to gift also? Gift can be done 100%.
in fact, that's a route they take nowadays. The father will give the property in case of children even when he is alive and ensure that the 2/3 problem is sorted out.
But only thing is, they cannot ring fence it. They have to protect their interest.
Yeah,
They can be
the
thrown.
point is, at what time do you advise a father?
Yeah, that's what.
See, nowadays you see, look at the North Indian, that big industrialists. You should be very, very cautious.
If the inheritance tax comes in India, wouldn't the trust be better than will that in that
No,
case?
see, I don't know, you are quite young. The Estate Duty Act was actually very detailed. For information, it had a concept called successive, that is, it's called quick succession relief. For example, A is there, A's son B is there, B's son C is there. B dies within a certain period, C dies within a certain period. Estate duty would be liable at every stage. When A dies, one liability, B dies, a second liability, C dies, a third liability. So there was a provision for quick succession relief. That is 1% is given as a discount and the balance you have to pay. So you may not be in a position to, trust is a good option if you create it, but it depends on how the law is made. Now that trust is very popular, they may very well cover it by some means. But if you have no beneficial interest, you have no legal ownership, and you have handed over all the property to the trust, then obviously estate duty law will not apply.
What is the chances of inheritance tax coming in India?
Very unlikely, because see, I had a very interesting case of estate duty which I have attended, hearing even an appeal. I don't know, nobody here would have attended.
1975, I think. Estate duty was applicable till 1975.
1975, but the litigations continued.
Yeah, litigations
See, there was a very big, very good very rich business family who had a huge property in Commercial Street. Now they had a lot of other wealth also. So the father died and the estate duty litigation started. The ITO who assessed for estate duty became a chief commissioner and then became a CBDT member. By then it had travelled to the Supreme Court and it came back. When the dispute started in 75, I was nowhere in the picture. Now when the appeal came up, I appeared before the commissioner. It was a second round. And again from the commissioner it travelled to the ITAT and to the Supreme Court. So estate duty collections were not adequate, like the wealth tax. That's the reason why you find that the Income Tax Act has been amended to collect. Gift tax. Collection was never adequate. That's why 56 to 10.
The cost of administration was more than collection.
And Income Tax Act is a simple act which you can catch everybody through. So That's the reason why they don't, they have abolished estate duty and even the wealth tax. Wealth tax Act collection was hardly anything. But in search and survey cases, search cases, even now, because wealth tax has got a limitation period, in certain cases where proceedings are initiated, this limitation period hadn't expired and they have reopened and issued notices for wealth tax also.
Sir, only self-acquired property can be linked or ancestral property can also?
Oh yes, see that's a very highly, we have to define what's an ancestral property. Anyway, ancestral property with a clock or ancestral property with no clock. For example, I get a property from my father and my father wills it to me and his father's self-acquired property and he tells me that I have absolute right and I can do what I want. Then I can will it to whomever I want, I can will it to a third party. But in the case of HU property or case of a property where a life interest is protected, that may not be possible. Anything else? Thank you. Thanks a lot.
Succession planning is something which has to be discussed successfully. Every time we resolve an issue, there's a new issue coming up and new tax challenge coming up. So, and sir has been very kind coming here and then giving us a lot of inputs on the whole aspect of it. Thank you so much, sir. On behalf of Bengaluru Branch, we thank you wholeheartedly for coming here. I request our chairman to hand over the memento to him. We have a big round of applause. Thank you so much, sir. Thank you, members, for making your time and attending this. Have a good night.